House and Committee for consideration of the Inquiries Bill, for further consideration of the Resource Management Reform Bill, and for consideration of the Insurance Prudential Supervision Amendment Bill. We first turn to the Inquiries Bill, and the question is that Part 1 stand part.
Mr Chairman.
The Honourable Trevor Mallett.
Mr Chairman, this is an interesting start to a bill, because within the preliminary provisions there are, Mr Chairman, some relatively important points, because within that the purpose clause is a purpose clause, and I must say, Mr Chairman, it's a very well drafted purpose clause, and I want to compliment the work of the Select Committee on that, and the Honourable Rick Barker, who were in fact, I was going to get right back to Sir Geoffrey Palmer. Well, shall we get the history right as to how this purpose clause got here? Annette King asked Sir Geoffrey Palmer to do some work. He gave that work to the Honourable Rick Barker. It was introduced into the Parliament before the 2008 election. It was sent to a select committee and had consideration during 2009. And it came back on the 20th of November 2009. Mr Chairman, I think it's fair to say that unlike the legislation that we have just been dealing with, this is something which has the broad support of the House. It is something which probably after 4 or 5 years in government, the Labor government realised that there was a gap, a pretty massive gap in the inquiries function and the ability to run inquiries. And just to make it clear for members who are not across it, a commission of inquiry or even a royal commission of inquiry are enormous undertakings. They are exceptionally formal. There are a lot of requirements around them. They are expensive and they are slow. At the other end of the scale, we have arrangements which can be made between the Prime Minister and the State Service Commissioner. And I think it's fair to say that the vast majority of issues which happen within the state sector generally can pretty easily be handled by inquiries that are set up by the State Service Commissioner at the request of the Prime Minister. But, Mr Speaker, there is an enormous gap where things go wrong in the private sector, or there are issues in the private sector that have to be dealt with, and ministerial inquiries find it very hard where there is not cooperation, where there is not transparency, to get at facts and to make conclusions. And therefore, after 4 or 5 years in government, the experience of a number of issues, it became clear to those of us involved in the previous government that it was important that we got something which covered that gap. And what we thought is, what is the right way of doing it? Could we take the approach that the current government takes to the GCSB and just sort of make it up? Or could we get a decent organisation to have a good look, to get a coherent piece of legislation coming back from that organisation and get it into the House and try and get broad support for it? And what we decided was that we would ask the Law Commission, at that time headed, I think, by Sir Geoffrey Palmer, someone who most people in New Zealand think is a well, the Attorney General seems to think that Sir Geoffrey Palmer has an inferior legal brain to his. Well, that is. Well, no, I don't. I actually don't. No, I disagree with my colleague about her cousin. I think her cousin knows he has an inferior brain to Sir Geoffrey Palmer and probably every other QC in the country, and as a result of that, we have some of the attitudes which flow through into the House. Inferiority complex or a number of other, there's some other expressions which could be used, but I'm told by the Deputy Leader of the Labour Party it's probably inappropriate to use those descriptions of the current Attorney General. But Mr. Chairman,
Honourable Trevor Mallard.
What became very clear to the previous government was that there was a gap and that we needed to fill it. So what we've done here is something which is designed to do that. It goes to questions around how the inquiry is going to be set up and how the members are to be appointed to it. That the actual detail of that comes in a later part of the bill. It goes to the powers and the duties and the privileges of the inquiry and the immunities that apply to the inquiry and to its members. And Mr. Chairman, that is something which is quite important. It is like exceptionally important in some cases. If I was David Henry at the moment, appearing before the Privileges Committee, I would be getting pretty anxious about the lack of immunities that I had granted by the Prime Minister in that particular case. Because, Mr. Chairman, when you have senior ministers, Jerry Brownlee, I understand, Judith Collins and Tolley, all turning on the Prime Minister's man, my view is he will be looking to some of his immunities and some of the protections and some of the resources which he's got because, Mr. Chairman, it is pretty clear that he has overstepped the mark, and I'm relatively certain that the immunities that he would require are not properly in place. There's questions that goes to the protection available for witnesses and counsel appearing before an inquiry, and later on when we get to clause 15, I will be moving an amendment, and I do want to acknowledge and thank the minister who is in charge of this bill. And I'll just say that last night there was a bit of confusion as to who is in charge of this bill, because last night we had Nathan Guy who was moving the bill. The bill was printed in Nathan Guy's name, but on the order paper it said it was in the name of Chris Tremaine. And what I've been informed by the learned clerk is that in fact it's the order paper that counts, and for good reason. When ministers of internal affairs have been, who was the first one? Was that Worth? Was he Minister of Internal Affairs? So we've had a bit of a tune, not a good history for Internal Affairs. Well. There's not a good history. They lost Richard Worth. They're almost certainly going to lose Nathan Guy. A short period after he was Minister of Internal Affairs, and frankly Chris Tremaine in matters which are going to become clear to people as to what's going on in Napier and issues of corruption around dams, is himself unlikely to be a minister by the time of the end of this government. Sorry? Well, I think it's fair to say I'll probably make it to the end of next year, but that will be that will be the end of it. But the point that I'm making is that in clause 15, which we will get to later, there are some protections, and I mean to move an amendment, but I can refer to it because I'm referring to clause 2C, which is the protection available for witnesses and counsel appearing before the inquiry, because, Mr. Chairman, this relates to that particular area. The Act does go to the 1908 Commissions of Inquiry Act and repeals. Well, I can remember talk of it. I can remember talk of it, Mr. Chairman, and I have been subject to, I think, 3 or 4 lectures from the Right Honourable Sir Geoffrey Palmer on the question of the Commissions of Inquiry Act, its benefits and its problems. And my advice to younger members who, sort of unlike me, are not at the midpoint of their career but are a way off it yet, might want to get that lecture from Sir Geoffrey Palmer because it is pretty informative, because it does go to some of the things which are really important about performing ministerial duties in an appropriate way. Mr. Chairman,
Grant Robertson.
Thank you, Mr. Chair.